today's story, we are dealing with a man who was accused of killing a cheerleader, and his first trial resulted in a mistrial. Prosecutors, of course, would like to try again. Now, normally this would not be a problem. Mistrials happen all the time, retrials happen all the time, but he's trying to argue he can't be retried because the prosecutor made misstatements and misdeeds that are going to bar prosecution. So, is he right? We're going to read an article, and then we're going to read a court case that's describing all this. So let's go ahead and get started with this. Attorneys for a man accused of Trinity University student's death have moved to bar the retrial, citing a potential prosecutorial misconduct and double jeopardy, therefore, that would result from the trial that had previously ended in a hung jury. The Bexar County Attorney Joe Gonzalez previously said he would retry Mark Howerton in the death. Defense attorneys announced this week they'd filed a habeas corpus. We're going to discuss that a little bit more. The law affords prosecution one full and fair opportunity to convict. Very true. And the prosecutor can do things that would bar their ability to prosecute again. Howerton faced murder, sexual assault, and kidnapping charges in initial trial. The jurors spent 9 days deliberating over 2 days as to whether or not the boyfriend, he was the boyfriend at the time, was guilty. Though the panel declined to discuss the case with the media after the mistrial, the foreman told the media the vote was 8-4 in favor of guilty. So that's a pretty split decision. I mean, 8-4. We're not talking one load holdout here. 8-4. That's a tough one to necessarily overcome. You're not talking 11-1, 8-4. I mean, that's, I know. The indictment against Howerton was remained in place as Gonzalez said we have every intention of going forward. Defense attorneys have also argued there has been misconduct by prosecution in their writ of habeas corpus. They said the state called an ex-boyfriend as a witness, and he testified they saw Howerton pull Mandady into the crowd at the festival after an argument. Data from cell phone towers and GPS showed that they were not at the festival at the time of the incident. So this eyewitness was at best wrong and at worst lying because they said, I saw him pull her into the crowd at this festival, but neither of them were at the festival. This isn't a case where the defense had to go up and prove that lie. The cell phone data provided by the prosecutor contained all the cell phone data to show that they couldn't have been seeing what they were seeing because their cell phones weren't there. At least is the argument. The state's decision to call this witness at trial and sponsor false statements in spite of evidence shocks the conscience. So the idea here is the prosecution is soliciting false testimony, which is definitely something you can't do. Solicitation of perjury is a no-no. The defense attorney continues that he decided to sponsor his testimony anyway because he's the only person to observe anything that would even remotely be violent. So it's all kinds of sketch. We're using apparent prior bad acts to prove this particular incident. We're proving something that may not have ever occurred and all the rest of it. Okay, so with that article sort of out of the way, now we're going to get into this decision relating to this ex parte Howerton, because we're going to try to charge him again, but maybe we can't. So we get to go to appeal right away because that goes to violating our fundamental rights and there's no ability to redress on appeal otherwise. So yeah, we get to see whether or not we can have this appeal or not. So, okay. So it says do not publish, which just means not to publish it in the physical volumes of books. So it's just a editorial note, basically. It has some legal value, but it's mostly just an editorial note, basically saying not to publish it because it doesn't create new law. Here's what happened, apparently. On the night of October 29th, 2017, Howerton drove his girlfriend, Mandady, a student, towards Houston, where he was from. They never made it. Around 10:30 that night, Howerton drove to the hospital in lowering Texas and finally got the attention of a paramedic. The paramedic found Mandini slumped in the passenger seat, not breathing, without a pulse, mostly naked, bruised, and bleeding, starting CPR. So they're on their way to Houston in a car together, and now he's flagging down the hospital staff, and she is mostly naked, bleeding, bruising, and not breathing. Howerton told the paramedic and responding officer that they had attended a music festival earlier in the day, and they consumed alcohol and ecstasy. Mandady later died. A medical examiner ruled the cause of death to be homicide, and manner of death to be blunt force trauma. So this does not sound particularly promising. A 2018 grand jury returned the charge of murder. These were based, at least in part, on grand jury testimony of a former boyfriend. So the former boyfriend had filed a police report in which Mandini did not return to her dorm room after the festival and could not reach her on the cell phone. The former boyfriend reported that he'd seen Howerton and Mandini at the festival that day and witnessed them physically pick her up, pull him into his car, and drive away. In later statements and grand jury, the former boyfriend reported he saw the couple at the festival, but only from afar. And he could tell how angry he was at her and saw him grab her and walk in the direction of the bars and exit. He tried to follow them, but lost them in the crowd. He immediately called Manditi's phone, and Howerton answered and told him Manditi was his, and Bertram needed to leave him alone. So these are a lot of potentially damning statements, but maybe none of it happened. Before the trial, Howerton filed a motion to dismiss, alleging the state knew or should have known that the grand jury testimony was false. So one of the things that the former boyfriend testifies is, I'm calling him, and he's picking up the phone. So his phone should be pinging off the towers in that area and have a GPS location in that area. But if it's not, then, there's a problem. According to Howerton, the cell phone records proved he never entered the festival, so it'd be impossible to prove that they entered the grounds. Howerton urged a rule based on due process, requiring dismissal of the indictment whenever the grand jury is provided with perjured testimony. So this call couldn't have happened because the phone shows they weren't in the festival, is the idea. All right, so now we have to have a whole thing about that. At the hearing on the motion, a digital forensic consultant testified he had reviewed the GPS data on the phones belonging to all the people involved. He created exhibits describing the phone's locations within 10 meters. The phone expert testified that the records show the phone on a road next to the stadium where the festival was held, but it did not appear as though Howerton entered the festival area. He drove past it, towards the East Highway and then north on 10. So they never got to the festival. They just drove past the festival, according to the forensics expert. They later testified the data from the phone placed them at the music festival several hours later, by which time Howerton's phone went near Trinity, almost 10 miles away. So things don't quite line up with the timeline. Gallant agreed there was no reason to believe from the data they were together or even line of sight of each other on August the 29th, on August the 22nd. So yeah, this didn't happen. The witness didn't see what they see, or the cell phone data seems to suggest. On cross-examination, they acknowledged the data only showed the phones were never together, not necessarily that they were never together. He also acknowledged they had no location data from the phone in the late afternoon to early evening hours, which could mean that they turned off the phone, among other possibilities. Howerton argued that cell phone data proved that Bertram, the former boyfriend, lied to the grand jury. He acknowledged the case law in Texas is sparse on the question of what happens when there's false testimony at the grand jury, but argued going forward on the indictment would violate due process, because they should have known it was false based on the records they had. Howerton was tried. Birch's testimony, the former boyfriend, testimony mirrored later statements in grand jury testimony. The former boyfriend admitted he lied in his initial report to the police about witnessing the boyfriend forcing the girlfriend into the car. That's kind of material. And driving off. So we're admitting to lying about that. And trial evidence showed that when Bertram placed the phone call to Manditi, the call he claimed to make very shortly after seeing them, and the call he claimed he answered, they were 10 miles away. So not so much with the timing. After the testimony, they renewed the motion to dismiss on the ground that Bertram's testimony did not match the data, showing that it was false. The trial court denied the motion at the close of evidence, but expressed exasperation at the state for sponsoring him as a witness and noted that defense had thoroughly discredited him. To be quite frank, no one's going to believe him, not about anything. So one of the things that you might think about is that this witness probably is not making an appearance at a second trial, because it seems unduly prejudicial at best. All right, so then the jury did its thing and did its 8-4 vote, in which case they couldn't convict. And so now we want to argue that the trial court erred when they concluded there was no prosecutorial misconduct, an exception to the general rule that mistrial resulting from a hung jury should not bar retrial should apply when the record establishes egregious prosecutorial misconduct. There's definitely concepts like that at law, sure. and the trial court abused its discretion. The courts have held that the right to trial before a jury is first selected is a right to a fair trial before that jury. This holding conflates double jeopardy protection with more generalized notions of due process and due course of law. The question for double jeopardy purposes is not whether the defendant's trial was fair, but whether the resulting mistrial was ultimately his decision. To say the decision was not the defense's own is to say the decision in reality was made by someone else, the prosecutor. But when the prosecutor is merely reckless, one cannot say the prosecutors made the decision to seek the mistrial. Only where the prosecution intends to provoke the mistrial can it be said the prosecutor has exercised discretion. This is more in keeping with the law. So yeah, as long as the prosecution isn't trying to get the mistrial deliberately, if they merely get carried away, it doesn't form a double jeopardy problem under the relevant U.S. law. That's correct. It's very disturbing, but very correct. This case involves a prosecution team that's asserted intended to win at any case and win at any price before the first jury, rather than trying to get its case to a second jury. The team's intent, though, is different, and under the relevant law, the distinction is crucial for double jeopardy purposes. Here, they do not allege the prosecution was the true actor behind the request for mistrial. The circumstances do not show the consent to mistrial was a sham. They moved to mistrial because the jury was hung, not because the state forced them to. The habeas court, in denying relief on double jeopardy grounds, follows the letter of the law as it was obligated to. Manifest necessity in the form of the hung jury was present to justify the declaration of the mistrial. They consented to mistrial, and the consent was not a sham. The retrial is therefore not barred. Because the double jeopardy claim fails as a matter of law, they do not need to go into the contention. They erred when they reached a legal conclusion that no prosecutorial misconduct occurred. So we're not even going to reach that issue as to whether prosecutorial misconduct occurred or not, because it's not relevant to our law. So based on the foregoing, yeah, not so much. Back to retrial for you. Thus, that brings us to the end of this article, at least for the moment, in this case of this retrial. So it seems like the prosecution may have been doing some dirty things indeed, offering this witness who the trial judge themselves found to be non-credible. So one would only hope, if there's a new trial, that this witness will not make an appearance, because they seem to be completely perjuring themselves and their testimony is non-credible. Although I guess ultimately credibility is a question for the jury, so it depends on which judge they get that day in terms of how that's going to go. So we'll see. But yeah, the previous trial was 8-4. So not really looking really great for the prosecution. But they're going to try again. And because that even assuming the prosecutor did the misconduct and all the rest of it is not enough to overcome the issues, so there will be a new trial, at least for a moment. That brings us to the end discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.